Good evening, everyone. I'm coming to you tonight live via Memorex. I know that some of you probably joined the legal profession with thoughts that you would get to travel to far off exotic lands. And as you watch this evening, I'm in the lovely metropolis of Waco, Texas. So it could happen to you as well. And as I told my wife when she asked me what I was doing in Waco, I am not talking to those people who from Home and Garden TV. She was greatly disappointed about that. By now you have probably seen your grade from our first assignment. Let me say that in general, I was fairly disappointed in our grades on this assignment. I was pretty disappointed in the effort that the class generally put out. Trust me, if you were disappointed in your grade, you were far from alone. This is what I was expecting from you, from the assignment. I was expecting 3 rep letters, one to the estate of married defendant, one to Exxon, and one to the insurance company. I would say very, very few of you got all 3 of these. I was pretty dissatisfied that most of you took my example rep letter and didn't modify it in any way, shape, or form. You just kept the same facts of a rear-end collision whenever the facts for our case is not a rear-end collision. It's an intersectional collision. The defendant ran a stop sign. Very few of you came up with an address for Exxon or for Allstate. Remember, I'm running this like I would a law firm. I'm giving you assignments, and I expect you to turn in ready to go out forms. I would expect the letter to Exxon to have the address for Exxon, to have the proper facts in the case. I would want the 3 letters modified, one for the insurance company, one for the employer, and one to the estate, which virtually none of you did. Again, I required a little bit of work to look up on the internet to find out the proper addresses for Exxon and for the insurance company, but certainly not difficult work. But again, most of you chose to leave it blank, and I was left to guess as to who this letter was from. I would be very disappointed if I was your employer and you turned in that type of work to me. The next things I wanted were the DPS forms for the accident report and for the driving record. Again, all you had to do was go to the DPS website and get those 2 forms. Very few of you did that. Most of you got a letter out of ProDoc, which I did not count all for, but I can tell you that DPS will not send you an accident report or a driving record based on that letter. They're a government agency and they want their form, so you still got to fill out their form. Again, I didn't take off for that, but you would not be successful in getting those if we were in an actual law firm situation. Back to the ref letter. Speaking of ProDoc, several of you, I assume, gave me a ref letter from ProDoc. I'm not really sure where it came from. Again, I didn't necessarily take off for that, but let me just tell you in general, if you go out to work for a law firm and that law firm gives you a form that they want you to use and you don't use it, it is not going to be looked upon very favorably from any future employer. And the last thing I wanted was a letter to Harmon Hospital, which requesting the medical records and bills, along with a HIPAA release and the medical and billing records affidavit. What I was looking for here is Harmon Hospital has a certain address that you have to send it to. Again, I would say the vast majority of you did not look up the proper address to get that. Also, Harmon Hospital has their own form that they require to get those records. I'm not sure any of you actually went to the trouble to either look it on their website or to make a phone call to Harmon Hospital to get that form. I have to say most of you did include a HIPAA release. As far as the affidavits, it's fairly clear to me that most of you don't understand the use of the affidavit. So I would say most of you just copied all the affidavits rather than the one that I specifically told you to use. Again, just left me feeling that you do not understand the affidavits or how they are used, which is troubling to me because in the week prior to this assignment being due, I did not get any requests asking me any questions on affidavits, and I went over them, I believe, fairly clearly in class. Again, not a good first effort out of you, but and I'm sure many of you think that I'm a difficult grader, which I admit that I am a difficult grader, but trust me, you want to make the mistakes here in class and not out in the workforce. You don't want to be going into your first job and turning in these type of paperwork. Your employer would not look very favorably on it. The good news is that if you are not happy with your grade, you can redo the assignment. Remember that I want you to do a short motion telling me that you're going to redo it, and you can turn in your assignment and you can get back up to half of your points. I'm sure we're going to do better as we go forward, but we'll put that behind us for now. All right, so we've signed up our case, and we've filed a petition, and the next part of the case is discovery. I'm sure that you've gone over this in your first civil procedure class. We'll go over it a little bit more in depth here tonight. Some general rules for discovery is, first of all, that the attorney must sign all discovery. This is to show that he's making a good faith attempt that this is relevant to the case. There are 4 types of written discovery. We have a written request for disclosure, interrogatories, request for production, and request for admissions. And we have an oral discovery as in oral depositions. And we also have depositions upon written questions. An important thing for you to remember as a paralegal is that you do not file discovery requests or responses with the court. It just mugs up the court system, and they don't want it. What instead is done is the attorney is required to keep a copy of all of his of the discovery through the duration of the case, as well as the any appeals in 6 months thereafter. That's Rule 194.1. For written discovery, you have 30 days to respond to all written discovery. If it is placed in the mail, you get an extra 3 days, so 33 days. An extra 1 day if it's faxed after 5. So back to your calendar, these are some things that are going to be going on in your calendar. Remember our discovery deadlines, which is our controlled by our discovery control plan, are not changed if trial is reset. I would say probably 70–80% of the time your first trial setting is going to be reset, but your discovery deadlines stay the same with that first trial setting. Kind of an obscure rule is that discovery must be served on the attorney in charge. What that means is, especially with defense firms, you'll often get your answer back with 4 or 5 different attorneys' names on the signature line. Usually there's a partner and 1 or 2 associates that are there, and whoever signs the first pleading is the attorney in charge. Now, if you do not serve it upon the attorney in charge, it is considered improper service and possibly untimely, and you can waive your objection. That's Rule 8. I will tell you, in my time, I've never ever seen this rule enforced. I've never seen anybody try to enforce this rule, where typically your attorney in charge might be a partner at a defense firm, but the one actually handling the case will be an associate, and you send everything to the associate attorney. Technically, that is incorrect, but I'm just telling you that just so you're aware of the rule. But honestly, I've never ever heard of this being enforced. You must always supplement your discovery if you find out it was incomplete when you answered it, or it becomes incorrect later. This is an affirmative duty that you have, so you be aware of that. And there's a big penalty if you do not properly respond to discovery. If there's a proper request for discovery and you do not respond to it or answer it, you cannot introduce the evidence that you failed to disclose or present a witness that you failed to disclose. So a pretty big penalty if you don't respond to discovery. Going on, first discovery is request for disclosure. What a request for disclosure is a set of standard questions that you can ask. These questions cannot be objected to and must be answered. You will actually see on your request for disclosure in this exact form these questions. You can get the correct names of the parties. So going back, remember sometimes it can be hard to determine the correct name of the defendant. You can file your lawsuit and send your request for disclosure and ask them the correct name, as well as any potential party. So if you can't determine who's the correct party, go back to our Bank of America example. You can ask them, is there another entity that's a potential party? You can ask them generally what their defense is to whatever the lawsuit is. This is you're not going to get back a whole lot of information here, but you can get back a general basis of what they're defending the case on. If they're making a claim for damages, you can ask them how much and their damages they're seeking and how they determine that amount. You can also ask for the names and addresses of people with knowledge of relevant facts. You can get information regarding their testifying expert, and it's important to note that this is the only way you can get information regarding a testifying expert. This and through taking their deposition. You cannot ask interrogatories about their experts, their testifying expert, and you cannot ask a request for disclosure regarding their testifying expert. You can find out if they have an insurance agreement covering the case, if they've settled with anyone, if they have taken any witness statements. Something important here to note is a witness statement is a statement that the witness is written down or recorded and signed. This is not where you have taken notes while talking to a witness. A very important distinction. Often as a paralegal, you'll be going out and investigating accidents. And when you talk to a witness, you'll want to, before you record a witness talking to you, telling you what his statement is, you want to talk to him and take notes and make sure that it's going to be favorable to your side before you get him to either write a statement or make a recorded statement. Your notes are protected and the other side can't get them, whereas if you get the witness to give a recorded statement, good or bad, you have to turn that over. So be careful when you're doing making statements or getting statements. If the lawsuit involves a physical or mental injury, you can get medical records and bills. You can also, the same thing, you can get any medical records and bills that the other side has obtained by virtue of an authorization. Typically, you'll have to give an authorization for them to seek the medical records on your client, and you're entitled to a copy of whatever they have gotten. And then also, you can get the name of any person who can be designated as a responsible third party. Our next set of written discovery is request for production. Remember, under Discovery Control Plan 2 or 3, these are unlimited. You can ask as many of these as you want. And under Discovery Control Plan number 1, you can ask 15 of these questions. Remember, you have to answer these 30 days, or send these out 30 days before the end of the discovery period, so that they have time to answer them. And you can basically ask for anything that's relevant to the case. You can also ask to inspect things, such as maybe there's a question on the brakes on a vehicle, so you want to inspect their vehicle. Maybe you have an accident scene, they slip and fell in a plant. Maybe you want to inspect the scene of the accident. This is how you do it, through your request for production and inspection. Our next one is interrogatories, which is Rule 197. Remember, here you're limited to 25 under Discovery Control Plan 2 or 3, and 15 under Control Plan 1. You still have that same 30 days, 30-day rules. You have to ask these before 30 days before the end of the discovery control period. And basically, you can ask them anything that is relevant to the lawsuit. This is very broad and far-reaching rule, and you can ask virtually anything, so long as you can come up with some way to make it relevant to the lawsuit. You can ask them what they had for breakfast that day, if you can think of a reason that that is somehow relevant to your lawsuit. Another written one is a request for admissions, which is Rule 198. These are unlimited under Discovery Control Plan 2 or 3. And you can ask the other party to admit or deny, again, virtually anything, including statements of opinion or fact or of the law. And remember, on this, you are limited in response. You have to word your question so that they can either admit or deny it. That is the only two responses that they are allowed to make. And it is important to note that if they fail to properly respond to this, the response is automatically deemed admitted. You will hear that you'll hear deemed admissions. So when you're drafting your request for admissions, you always want them to be where you want the other side to admit it. If they admit it, it is good for your case. Again, you have to send these out 30 days for the end of the discovery control period. And the other side is limited. They may qualify the answer or deny it in part if you're asking a multi-part, but they have to have a good faith basis for doing so. If you're going to say that you do not know the answer, if you lack information, you can only make that if you have made a reasonable inquiry to determine what the answer is. So let's say you get into an admission, admit or deny that John Smith witnessed the accident, and you don't know if John Smith witnessed the accident. You may be forced to make a reasonable inquiry, look at the accident report, and see if John Smith was listed as a witness or not. Here is our effect of failure to respond. So if you miss your deadline, again, this goes back to calendaring, so that if you have 30 days to respond to your request for admissions, and you send them in on day 31, you have just untimely answered those requests for admissions, and you have deemed them all admitted. So and probably committed malpractice. So let's always make sure that you get your requests for admissions out timely. Here's some good requests for admissions. What I see in coming across my desk, especially from young attorneys, they do not understand their request for admissions very well. They often misuse them, and it's just kind of a waste of time. They don't ask them properly, so that you have to admit your question. Here's a question out of my own files. Admit or deny on this date, such trucking company was the owner of a 1992 blue Kenworth conventional tractor with certain license plate number. What this request is getting to is in most large trucking companies nowadays do not actually own the trucks. They're almost all leases. Excuse me. So they're trying to find out who the owner of this vehicle was. And what I think is a very good way to do it is to pair your request for admissions with a request for production. They do not have to be separate documents. You can combine them. And they ask if we didn't admit that we were the owner of the truck, and they want to know basically who was. So I can't claim credit for these. I was actually representing a trucking company in this accident. But a good use of these request for admissions as well as request for production. Another question out of that same case. Here they were asked to admit or deny that Gianni D was the operator of this truck while in the course and scope of his employment. Similar to the truck, a lot of times with big trucking companies, they do not have drivers. They lease the drivers as well, and such was the case here. We denied that he was in the course and scope of his employment. They followed it up with a nice request for production, asking us why we were denying it. And so we attached a copy of our lease contract with the leasing company. And finally, they were asking here, admit or deny, whether or not we conducted a background check, which we denied, and then we responded with what we did as far as a background check on our driver. Now getting on to something I see a lot more common, which is a bad use of requests for admissions. Again, out of my own files, here we were to admit or deny that defendant was required to have insurance coverage by defendant in order to perform electrical work. This accident involved an electrical accident, which unfortunately the plaintiff was killed in an electrical accident. I was representing the electrical company that had done the work. Then this attorney followed it up with we were not required to have insurance coverage. So you can see first they asked we were, second we asked we were not. So if in fact, remember, if you are drafting these, you want it to always ask the question so that you admit it. We would admit that we were required. We would admit that we were not required to have it. So they would counterbalance it, and these would be completely worthless to the plaintiff in this case, as far as request for admission, regardless of the fact that insurance coverage is not admissible in court. So I don't really know what they were driving at anyway. Here's how you object to a request for admissions. This is out of that same case that defendant did not have written document that identified the second or third parties and their division of responsibility for lockout tagout. Well, first of all, I don't really understand the question. I don't know what second and third parties and or their division of responsibilities have anything to do with lockout tagout procedures. So here we have our objection. Remember that if you're going to use lack of knowledge, you have to say that you've made a reasonable inquiry. So defendant has made a reasonable inquiry and found that the information known or easily obtained by defendant is insufficient to enable defendant to admit or deny the request. This is magic language. You have to have this language in there if you're going to be objecting to a request for admission on lack of knowledge. Then the defendant objects to this request on the following specific grounds. More magic language. You have to have this in your objections. I'm giving you a hint here for your homework tonight. You're going to be doing objections. So make sure this language is in there. And then we have our objections. The request is unduly burdensome, harassing, and annoying, too broad, vague, and general, and we were unable to determine the meaning of this request. So again, this is magic language. If I don't see this language in your assignment that you're objecting on specific grounds, I'm going to assume that you did not watch this video, which I guess if you didn't watch the video, my warning is worthless anyway. So what can you do when you're responding to discovery? Everything we've worked up to is sending discovery, so how can you object or not respond to discovery? The first thing is work product. which is Rule 192.5. Basically, anything prepared in anticipation of litigation or trial by the party's representatives, including attorneys, consultants, sureties, indemnitors, insurers, employees, or agents. So basically, if it was prepared, getting ready for trial, or getting ready for, or anticipation of litigation, that's considered work product. And it's not just attorneys, it's everybody in the attorney's office. So the work you're doing as a paralegal, by definition, everything that you're doing is considered work product. And this includes communications between the parties in anticipation of litigation. So that's work product. So how do you assert it? Rule 193.3 tells us this. Now, I was asked the other day what I was wanting you to do with the O'Connor's book. Let's say y'all had some questions on asserting a privilege. Well, look up Rule 193.3, read the rule, read O'Connor's explanations to the rules. O'Connor's probably got 30 pages on how to assert a privilege. So when you're doing your homework, if you have a question, they'll tell you how to do it. So if you're claiming a privilege, how do you do it? You must state in your response that you are withholding information, that they have asked a question, you have information that is responsive to it, but you are withholding it. You must state specifically what the request, the information relates to. Typically, that's pretty easy. You just put it right after whatever question it is, and you state the privilege. So you state work product, that you have information responsive to the request, and you're not providing it to them because you have work product. So here's this little example. Here they're wanting notes that you took during your inspection of the accident scene. So you tell us this request information which is privileged by the work product doctrine, and plaintiff specifically states you always want to have this magic language in there. You want to always object specifically and specifically state what your objection is. General objections are specifically invalidated in the rules. So you always want to object specifically, not generally. So you have your little statement, just like from the rule, that information or material responsive to the request has been withheld pursuant to the work product privilege. So again, just straight out of the rule, you're withholding information. You're putting it right after the question, so that part is ascertainable, and you're specifically getting your what privilege you are using. When you're making objections, you can object to questions that are outside of the scope of discovery. Generally, discovery in a case is very broad. You can ask anything so long as it is relevant to the case. It does not have to be admissible at trial for it to be relevant. They can ask you questions that are not admissible at trial. Go back to that request for admission. They were asking insurance information. Insurance information is not relevant, not admissible at trial, at least not in the vast majority of cases. But they can still ask it because it's relevant. So anything that is relevant to the case, like I said, you can make up an argument that virtually everything is relevant to a case. There are very few limitations on that. The first being that if they've asked questions that are unreasonably cumulative to you, or that The information is available from another source that is more convenient, less burdensome, or less expensive. Also, it is an objection if the expense of the proposed discovery outweighs its benefit, taking into account how much is in controversy, the party's resources, the importance. Back in the day, one of the common things was to sue credit card companies for basically bad faith and improper collections procedures. One of the things that the plaintiffs would do is make a request essentially for all their records on all their millions of account holders, and for essentially $10,000 in controversy. They'd ask for discovery that would take the Visa, for example, $15 or $20 million to respond to, just in hopes of getting their $10,000 settlement. And basically, the court did put a stop to that. But under this rule, Visa could object that, hey, it's going to cost me $10 million to respond to this request for production, and we're talking about a $10,000 case, so it doesn't make any sense. So when do you file your objection? You file your objection at the same time or before the response is due. So if you have 30 days to make your response, you have 30 days to make your objection. If you're making an objection and to only part of the question, you have an affirmative duty to answer the rest of it. So if they ask you a question, let's say that's overly broad, but part of the question is relevant, you have a duty to respond to that. Let's say you're involved in an auto accident and they've asked you for your employment history for your entire life. Well, how is it relevant that you worked at Dairy Queen when you were 15 years old? So you can make an objection stating that the request is overly broad. However, you could respond with what is relevant. Maybe your last 5 years of employment history. As always, you must have a good faith basis for an objection. If you find out that an objection that you made is no longer valid, you have an affirmative duty to amend your response and to go back and answer the question that you previously objected to. And remember, if you are untimely, if you don't answer it timely, or make your objection timely, you have waived that objection and you must answer it. As well as if you have made what is a valid objection, but you have obscured it by numerous unfounded objections, then you have again waived your objection. This is something I see fairly common, typically from younger attorneys. Here's one straight out of my files here, where the defendant objected and literally lists every objection in the book to the question. So I would say that whatever the proper objection was, if there was a proper objection, it has been obscured by these unfounded objections, and the court could find that you have waived that objection. Again, for tonight's class, y'all are going to be answering discovery or not answering discovery. I just want you to object to the discovery. Here are the sample objections I use. These are certainly not all the objections that are out there, but these are probably in the vast majority of the cases. First of all, remember your magic language. You're always going to object We identify what we're objecting to in the foregoing interrogatory, and we always object specifically. Again, if I get in responses that don't include this language, I'm going to be quite disappointed. First one, remember that you can only ask about relevant information. So obviously the first objection is that the interrogatory seeks information that is not relevant. I always, when I do my objection, I like to cite my rule if possible and cite case law. The reason for that is if we ever get into a discovery argument where we have to go before the judge to go over our objections, see if they're valid or not. A lot of things are happening at the bench. Don't necessarily have time to be looking at case law. And here I've already got it. So if a judge asks me, what my basis for my objection is, I say, Judge, it's 192.3, as well as the CSX case. So I have that right there handy for me, if possible. Remember that information regarding your testifying expert is only available through request for disclosure. So that's an objection. I still see that fairly common, where they ask questions on your testifying expert. You can only respond with what you've got. So if they ask for information that's not available to you, then that's a valid objection. If you can't figure out the question, which surprisingly happens quite often for a bunch of attorneys who are college graduates as well as law school graduates, it's amazing how we can muck up a question where no one can understand it. Some more sample objections is if they ask more than 25 interrogatories. Good thing to note here is that the rules do not say what 25 interrogatories that you must answer, only that you must answer 25. That the rule does not say you have to answer the first 25 or anything like that, so you can pick and choose which 25. The request is overbroad, harassing, and annoying. The courts have determined that you cannot request all documents without limitations on time, place, or subject matter. So essentially, if you see a request that says all, that is almost always objectionable. The preeminent case on that is Lofton v. Martin. It's a very good read if y'all are interested in discovery objections. That's probably the number one case cited in discovery type disputes. Objection here, the request seeks plaintiff's trial exhibits. They are not, each side is not entitled to the other side's trial exhibits unless the court orders them to be disclosed, which if you go back to our discovery control plan, typically as part of that discovery control plan, the court does eventually order you to disclose trial exhibits, but it's usually not until about a week or two before trial. So obviously I don't want to provide my trial exhibits. The danger here is if you don't object and then you don't give your trial exhibits, and then you have potentially, remember our penalty if you don't respond to a proper request or object to an improper request, you may not be able to introduce it into evidence. So here I've got my trial exhibits, and I forgot to object to this request asking me to give them to them, and I didn't give them to them because typically you don't make your trial exhibits until a week or so before trial. I could potentially not be able to get my trial exhibits in front of the jury. So this is a big one to remember to object to. If they ask you to provide all your evidence, that is also impermissible. It's called a fishing expedition. You cannot be required to marshal all of your available proof. Again, that's Rule 197.1, as well as the Kmart case. So tie that all together, and how do we object to this? Okay, here they're asking for the net worth for the past 5 years. Plaintiff's net worth is virtually never relevant to a lawsuit. So again, we're objecting to the foregoing request, and we're objecting specifically. So we're objecting that it's not relevant and will not lead to admissible evidence. Another example. Here they're asking for some treatises that you're going to be using at trial under Rule 803.18. An important hint. When you see this, actually look at the rule. That's what books were invented for. You'll find that this rule has nothing to do with this question. So again, we're objecting to the foregoing, we're objecting specifically, and we're objecting that they are requesting our trial exhibits as well as an impermissible fishing expedition. Here, again, we have a request for all documents. So we have our famous Lofton v. Martin case. And we have forgotten our specific question. So this could potentially be improper, because we have not objected specifically, as well as they requesting information that is not relevant. All right, moving on to depositions, something else that you're going to be doing as a paralegal. Typically, 90% or possibly more of all depositions are done by agreement. You will decide that you want to take someone's deposition. You call the other side, get an agreeable date, call the witness if he's not represented, get it all set up. Sometimes it can be difficult. Get 5, 10 people that you have to all coordinate. So sometimes difficult to get a date. But that's something that you're going to have to be doing, is setting up depositions. If you have someone that's not represented, say such as the witness, that you're going to have to, first of all, you want to talk to them, see if they will agree to a deposition. But if you need to subpoena them, you have to file a notice of deposition and subpoena them. Obviously, in that notice, you have to provide the time and date where it's at, identify whose deposition you're taking. If you're subpoenaing them, the place has to be either the county of the witness's resident or where he's employed. It could be in the county of suit. So if he's employed, say, in Harris County, but the accident happened in Fort Bend County, you can do that. But it must be within 150 miles of wherever he is served with his subpoena. And basically, if y'all can't do that, the court can order a place that is convenient. But almost all depositions, you do not have to subpoena people. You usually talk them into it, and you just reach an agreement on what you're going to do. If you're going to videotape or record the deposition, you have to provide that in the notice. If you don't provide that, it's proper to object, and it's proper that you can walk out if you want to. If there are going to be people there other than the parties and their lawyers, or employees of their lawyers, that has to be included in the notice. Sometimes if you're taking an expert's deposition, you might want your expert there to help you understand if it's a particularly complex area. So if you're going to do that, you have to let the other side know that you're having your expert attend the deposition. if you want the other side to bring any documents, you have to put that in there. You know, what documents you want to them to bring. Important to note here, though, if you ask them to bring documents, you have to give them at least 30 days notice, the same as a request for production, to get the documents together. So you put all that together, and you have yourself a short and sweet deposition notice. You send it to whoever you're sending it to, and say that you're going to take the oral deposition. You identify the person, date and time, place, as well as the fact, well, here this is not a videotape deposition, so I'd typically put that I am taking this deposition via videotape. So short and sweet, like I said, 99, or that's a little much, but 90% of the time, this is all agreed upon, a few phone calls, and you get this figured out. Let's say you get in an oral notice of oral deposition that you need to object to, that you object to the time and place. You got the other 10%. That's covered in Rule 199.4. And what you have to do there is quash the notice of deposition. Notice that this is quash and not squash, so don't make that mistake. If you get in a notice of deposition, you can file your motion to quash. If you do so by the 3rd business day, then the deposition is automatically stayed. The reason for this rule is usually you can get in notice of deposition. Let's say it's for a week later. Here we're sitting here on Thursday, and you get a deposition notice, and it's next Thursday. You have an objection to the time and place. Well, sometimes it would be very difficult to get a court ruling before the deposition is supposed to take place. So it would be very difficult to get in front of the judge before that deposition. So you have to file your notice by the 3rd business day. So if you get it today on Thursday, Friday, Monday, Tuesday, so you have to file it by Tuesday, and you will automatically stay that deposition, and it will not be allowed to go forward. So here's your motion to quash. Again, just short and sweet, doesn't have to be complicated. Get yourself a brief introduction. Now you've gotten your facts here. Plaintiff notice of deposition for a certain date and time. Counsel, again, this out of my own files. Counsel will be out of the country on vacation. They didn't ask me if I was available on said date. And I have no other attorney available to me who could handle this deposition. And then I state the rule that because this notice was filed within 3 days, is automatically quashed. Again, our standard little prayer. And the important thing here, I didn't include it, is since we have facts in here about dates, we have the dates that they forwarded to us, and we have that we're filing it within 3 days, that has to be verified. So I would need to, or the attorney would need to verify this motion. Just a simple little statement stating that I swear that these facts contained in the motion are true and correct. It's on the next page, and I didn't copy it over here. But remember that if you ever filing anything that you file that has facts in it that are not readily attainable, you have to swear to it or verify it. You know, things like dates. All right, so we're getting on to our next assignment. I'm sure we're going to do a good job on this. First of all, I received a deposition notice that they didn't ask me about the date. I'm in court-ordered mediation I want you to file a motion to quash. Do it within 3 days. I also want you to notice the video deposition of Joe Hunter, who is our defendant driver, Mary defendant's supervisor. I'm also attached some discovery. I want you to go through it, and if a question is objectionable, I want you to attach the proper deposition, the proper objection. You do not have to respond to the discovery per se. I don't want you to come up with answers. All I want to see is that you can identify an objectionable question and you can object to it. Important to note, like I stated, I'm in Waco. I won't be back until Saturday. I'm going to have some fairly limited contact. So if you do try to get hold of me, it probably won't be until Sunday that I am available. Good luck to y'all. Hope y'all have a good week, and I will be talking to you next time.